Good evening. Welcome to Constitution Day. Like all other holidays, Constitution Day has its own history. In 2005, the immortal Senator Robert Byrd of West Virginia attached an amendment to a massive appropriations bill. Byrd's amendment required that every year on September 17th, the date the Constitution was actually signed, that federal employees receive educational and training materials about the Constitution. It also required that all schools receiving federal funds, including universities like our own, must provide a program on the Constitution. So that is why we are here tonight. And at the outset, we'd like to thank the Provost's Office and Royce Engstrom for sponsoring this program. It's been our tradition to have a speaker from outside the university come and talk on Constitution Day, but today, or this year, we decided to rely on some of our own trusted experts. In particular, Professor Michael Mayer. He's a professor in the history department here at the University of Montana. He teaches a variety of courses in United States history, including specialized courses on post-World War II culture, the history of American law, as well as courses on the 1950s and the 1960s. He received degrees from Duke University and his PhD from Princeton University. And he's published several important books and articles on America in the 1950s, the Civil Rights Movement, and the Eisenhower presidency. His most recent book, The Eisenhower Years, was published by Facts on File. It's actually in press as we speak. You can actually go to Amazon.com and pre-order your copy at a very affordable price. This book is going to be the absolute go-to resource for students and scholars of the 1950s. Mike's talk tonight is entitled, I Know It When I See It, Obscenity in the Constitution. Please join me in welcoming Professor Mike Mayer.
Is this? Yeah, it's on. Thanks, Kyle. Check's in the mail. I want to thank Lisa Thompson from the Provost's Office, who was a lot of help and in setting this up. And to explain a little bit, we lost a speaker this year to the budget crisis in California, so I'm kind of a pinch hitter. The issue of censorship is highly controversial, really only in this country. It's the norm everywhere else in the world. Even countries we regard as democratic and open, places like Great Britain, the British Commonwealth countries, regularly censor movies, plays, and books, and not just for obscenity, but for political ideas as well. This country, though, has a commitment, at least in theory, to unregulated speech and unregulated press. The commandment of the First Amendment is plain. Congress shall make no law abridging freedom of speech. And yet our courts have consistently held that the freedom to speak is not absolute. Things like slander, libel, incitement to riot are outside the law. And as Justice Holmes famously pointed out, no one has a right to cry fire in a crowded theater. Aside from these relatively clear instances, there are other pressures on the freedom of speech. The legal scholar Thomas Emerson, one of the great specialists on the First Amendment, wrote of, quote, the powerful forces that impel men toward the elimination of unorthodox expression. And you just need to think back over the last few decades to the attacks on Salman Rushdie for his satanic verses, on the movie The Last Temptation of Christ, on periodic attempts to remove Huckleberry Finn from public and school libraries, or the attempts on this campus to impose hate speech codes in the early 90s. One particularly difficult area, I think, of constitutional law is obscenity. There are those people who want to rid society of what they consider a blight, or even a danger. And there are those people who believe that speech should be unfettered. The result of trying to balance free speech and the public's demand to suppress obscene or offensive material creates powerful tensions. Justice Thurgood Marshall put it pretty well when he said, if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his house what books he may read or what films he may watch. That was in 1969, before people actually could watch films in their homes with the ease that we have today. And yet the public and America's courts as well have long considered obscenity, like libel, misrepresentation, or fraud to be outside the protection of the First Amendment. In spite of that, the courts have had a great deal of difficulty trying to define what obscenity consists of. And I think as a result of that, the law of censorship and the law of obscenity is, as one scholar put it, a constitutional disaster area. Part of the problem is obscenity often reflects changing social and ethical and religious values, and we have a complex and pluralistic society. Let me just give you one, I think, telling example. In 1953, Otto Preminger's movie, The Moon is Blue, was denied the motion picture seal of approval because it contained the word virgin in its dialogue. In 1966, just 13 years later, the rough language Elizabeth Taylor spoke in the film version of Edward Albee's play, Who's Afraid of Virginia Woolf, was becoming maybe not quite conventional, but it raised not much controversy, maybe a few eyebrows, but not a lot of controversy. Phrases such as hump the hostess and up yours didn't create the kind of furor that the word virgin in dialogue created 13 years earlier. And so it becomes very difficult to define what is obscene and what isn't. And attempts to define obscenity and to enforce its suppression have led to some pretty ridiculous situations. I think as a society, we look back with some embarrassment at ourselves, at our own society, which made it a crime to sell Theodore Dreiser's American Tragedy in the 1930s. In the 1940s, suppressed Lillian Hellman's Strange Fruit, which is a book essentially about racial hatred. And as late as 1948, New York suppressed Edmund Wilson's Memoirs of Hecate County. Only one chapter of that has much to do with sex, and those of you who are familiar with Wilson's work probably are pretty aware that it wouldn't be very rough by today's standards. Throughout the 1950s, Henry Miller's works were available in his own country, this country, only in smuggled copies. D.H. Lawrence's Lady Chatterley's Lover was unavailable in the United States as well. And among the most ridiculous results of our attempts to save ourselves from ourselves is the institution of Movie Day at the United States Supreme Court, when the justices and clerks gather in a basement room to watch the exhibits in obscenity cases. When Justice Harry Blackmun sat through his first Movie Day, an experience he clearly did not particularly enjoy, Thurgood Marshall, the court's great prankster, picked up on the fact that a number of the films presented themselves as educational. When it was all over, he turned to Blackmun and asked, "Well, Harry, I didn't learn anything new. How about you?" Blackmun blushed and joined the rest of the court in a laugh. One movie, in order to establish redeeming social value, began with a doctor, an actor playing a doctor, in a white jacket, explaining the symptoms of nymphomania. The rest of the film demonstrated the exploits of a nymphomaniac, and the film ended with the doctor again on film reporting, "I'm sorry to say that Laura was never cured." Marshall, the court's great prankster, once again jumped up and cried, "But I am," and bolted from the room. Justices Hugo Black and William Douglas never attended Movie Day. In their view, the First Amendment was absolutely clear. Nothing could be banned. Black said, "If I want to go see that film, I should pay my money like everyone else." And Black was known to grumble about the Supreme Board of Censors and wondered aloud why 9 men, many in their 70s, should make judgments about sexuality. The law of obscenity in America goes back, as most American laws do, to England, to the 19th century, to a case called Regina versus Hicklin, or in other words, the Queen versus Hicklin. In that case, the British courts held obscene an anti-Catholic pamphlet published by the Protestant Electoral Union. The pamphlet's title, I think, gives you an idea of what it might have been about. The Confessional Unmasked, showing the depravity of Romish priesthood, the inequity of the confessional, and the questions put to females in confession. The test used by the judge in this case was, quote, "If the tendency of the matter is to deprave and corrupt those whose minds are open to such immoral influences, and into whose hands a publication of this sort might fall." Obviously, the purpose of the pamphlet was political and religious, but the judge held that it would suggest, quote, "thoughts of a most impure and libidinous nature." The Hicklin test was imported to the United States in 1879 and continued to dominate American constitutional law regarding obscenity. There were several events. One of my favorite is in the 1920s. The Port of Baltimore seized Aristophanes' Lysistrata, and Mary Stopes' Wise Parenthood as obscene. But the key test in modern obscenity law came in 1933 in a case known as the United States versus one book called Ulysses. In that case, Judge John Mosley, the federal district judge in New York, relied on expert witnesses to sustain the literary value of James Joyce's novel. The appellate court, in a decision written by Judge Augustus Hand, ruled that the dominant effect, rather than individual isolated passages, had to be considered. They upheld Woolsey's use of expert witnesses. Essentially, that case confirmed the Hicklin test. The judges simply concluded that Ulysses wasn't really all that lustful, or as Hand put it, the erotic passages are submerged in the book as a whole and have little resultant effect. The next major constitutional case came several decades later, or at least a couple of decades later, in 1957, in Butler versus Michigan. Felix Frankfurter, speaking for a unanimous court, threw out a Michigan state law that banned books, quote, containing obscene, immoral, or lewd or lascivious passages, language, pictures, or descriptions. The law was intended to protect young people from the potentially harmful effect of such material. But the case arose when a bookseller sold a book that came under that law, not to a minor, but to a police officer. Frankfurter wrote that the law attempted, quote, to quarantine the general reading public against books not too rugged for grown men and women in order to shield juvenile innocence. Surely, he observed, this is to burn the house, to roast the pig. The effect of the law, he said, would be to reduce the adult population of Michigan to reading what is fit for children. He concluded, quote, we have before us legislation not reasonably restricted to the evil with which it is said to deal. That same year, the Supreme Court dealt for the first time with the question of whether obscenity was in fact governed by the First Amendment. The case, which is known as Roth versus the United States, was really two cases. The second case was Alberts versus California. They produced a single opinion. This is an interesting case in many ways. Samuel Roth was a man of considerable culture, and some of the material he sold was undoubtedly literature. Some of the material he sold was pretty cheap. But Roth was convicted under a federal statute prohibiting the mailing of obscene materials. Alberts was a smut peddler. He didn't have quite the same quality as Roth. And he was convicted under a California law that prohibited circulation of obscene literature which, quote, offends the conscience of the community. The court upheld both convictions, and Justice Brennan, William Brennan, writing for a majority, wrote, all ideas having even the slightest redeeming social importance, unorthodox ideas, controversial ideas, even ideas hateful to the prevailing climate of opinion, have the full protection of the Constitution. But, he concluded, obscenity is not within the area of constitutionally protected speech or press. To justify it, he simply asserted, quote, this court has always assumed that obscenity is not protected by the freedoms of speech and press. He found that this federal statute banning obscene materials from the mail was, quote, a proper exercise of postal power. He did say that any idea, quote, having the slightest redeeming social importance could claim First Amendment protection. But then he turned to the question of what was obscenity. He wrote, and many will be glad to hear this, sex and obscenity are not synonymous. He distinguished between sex and obscenity. He said, obscenity is material, quote, which deals with sex in a manner appealing to prurient interests. Well, what are prurient interests? He defined that as, quote, impure in thought and desire, lewd, having lustful cravings or desires. It was material, as Brennan said, utterly without redeeming social importance. Brennan rejected the older Hicklin test, which judged material by its effect on the most vulnerable, the most susceptible persons. In its place, he put forward a standard that was already pretty widely in use in American courts. And the standard was this: whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interest. Brennan's opinion spoke for a majority of 5. He was joined by Frankfurter, Clark, Burton, and Whitaker. Chief Justice Warren voted to affirm the convictions, but he had different reasons. Justice Harlan concurred on Albert's conviction because he violated a state law, and he believed that states should be given greater latitude than the federal government. He did not agree with the conviction under federal statutes. Justice Douglas dissented, and he was joined by Justice Black. He wrote, "The court's standard of, quote, community conscience inflicted punishment for thoughts provoked, not for overt acts or antisocial conduct. Therefore," he said, "the law violated the First Amendment. Speech and writing," wrote Douglas, "might be suppressed only when they amounted to conduct, or, as he put it, are so closely brigaded with illegal action as to be an inescapable part of it." For Douglas, in order to be outside the protection of the First Amendment, speech had either to be act or so closely associated with an act that it was part of that act. The First Amendment, he said, was meant to block censorship in any form. And he warned, quote, "The test that suppresses a cheap tract today can suppress a literary gem tomorrow. I have the same faith in the ability of our people to reject noxious literature as I have in their capacity to sort out the true from the false in theology, economics, politics, or any other field." Brennan's formulation was clearly intended to protect Faulkner, Joyce, Erskine Caldwell from overzealous prosecutors, but still to allow the government to suppress material that was, in his view, truly obscene. The effort wasn't entirely successful. And by denying constitutional protection to obscenity, he led the court into a futile attempt to define what obscenity was. For 2 decades after Roth, the court struggled to define what was obscene. To give you an idea of how difficult this was, between 1957 and 1968, there were 13 cases the Supreme Court decided relating to obscenity. The justices wrote 55 separate opinions. They couldn't agree on anything. And in all of the cases, the justices seemed preoccupied not with the real First Amendment test, what interests would justify restraint. They wound up dealing with what is obscene. And the court, or at least a majority, seemed to believe that whatever it was, obscenity fell outside the protection of the First Amendment, but the Warren Court never established a workable test to separate obscenity from sexually oriented but constitutionally protected speech. Black and Douglas, sometimes joined by Fortas, Justice Abe Fortas, consistently argued that the state simply should not censor speech. In a series of cases, you see some curious results. The court overturned censorship of the film version of Lady Chatterley's Lover in 1959, but the next major test came in 1964. That case was Jacobellis versus Ohio. The case dealt with the licensing of a French film, Les Amants. The English title was The Lovers. The movie portrayed the story of an unhappy marriage. A woman is bored with her life and with her marriage. She leaves her husband and family, believe it or not, for a young archaeologist. You know that's fiction. But near the end, the film presented a love scene, fairly explicit, perhaps meant to portray sexual intercourse. Justice Arthur Goldberg observed, quote, "The love scene deemed objectionable is so fragmentary and so fleeting that only a censor's alert would make an audience conscious that something questionable was being portrayed." But the case involved the manager of a theater who was arrested on 2 counts of violating Ohio law for possessing and distributing an obscene film. Brennan once again announced the opinion of the court. It really was a controlling opinion. There was no single majority opinion. Only Goldberg joined him. In this case, Brennan expanded the Roth test. First of all, the community involved had to be, as he put it, the whole national community. And he stressed the need to demonstrate that the material lacked any redeeming social importance. He admitted that, quote, "prurient interest as a standard," the standard he offered in Roth, wasn't perfect, but as he wrote, any substitute would raise equally difficult problems. But he did indicate very clearly the mere portrayal of sex was not in and of itself sufficient to deny material the constitutional protection of freedom of speech and press. But he sharpened the Roth test, trying to make it more explicit. He incorporated Harlan's requirement. The community standards should be national, not local. And then using these refined guidelines, he simply found that the film was not obscene. Chief Justice Earl Warren, joined by Tom Clark, dissented. Warren wrote, "I believe there is not a provable national standard, and perhaps there should be none. At all events, this court has been unable to enunciate one, and so therefore," he said, "the enforcement of Roth should be left to the lower courts. And the Supreme Court should accept their findings except when there's insufficient evidence to support the lower court's finding." In this case, he says, you simply can't say the courts below acted with intemperance or without sufficient evidence. Harlan dissented. He said states should be left pretty much alone in how they handle this. But Potter Stewart concurred with Brennan. He wrote, "Only hardcore pornography could be suppressed." And then he had to discuss what was hardcore pornography. He wrote, "I shall not attempt today further to define the kinds of material I understand to be embraced within that shorthand description. And perhaps I never succeed in intelligibly doing so. But I know it when I see it. And the motion picture involved in this case is not it." The decision still left state censors with a pretty free hand. On the same day as Jacobellis, the Supreme Court reversed a ban on Henry Miller's Tropic of Cancer. What you see in the court's activities from Roth on, particularly Brennan's decisions, is an attempt to protect serious literature and to distinguish it from pornography or obscenity, which Brennan believed could be banned. But the lower courts continued to hold obscene material that he was pretty sure wasn't obscene, and he wanted to address this problem. In 3 decisions handed down in March of 1966, he got his opportunity. The 3 cases were Ginsburg versus US, Michigan versus New York, and Memoirs versus Massachusetts. In Ginsburg, the Supreme Court upheld the conviction of Ralph Ginsburg for violating a federal postal censorship law. Ginsburg was fined and sentenced to 5 years in prison. His defense counsel argued that the material he distributed, standing alone, did not rise to the test established in Roth for obscenity. The material involved was a book. It was titled The Housewife's Handbook on Selective Promiscuity. It purported to be a sexual autobiography of an anonymous female from the ages of 3 to 36. This is going to surprise you, but it appeared to have some serious intent, or at least several doctors and psychologists thought it did. And the other material included 2 magazines, Liaison, which was a bi-weekly newsletter filled with smutty jokes and sensationalist pseudo-medical sex stories, and Eros, a very high price. It was $10 an issue. Can you imagine that back in the 60s? That was an expensive magazine. It was hardcover, published quarterly, and devoted to what it described as an intellectual examination of erotica. Brennan wrote for a once again divided court, 5-4. He didn't deal with the defense argument that if you just look at the material, it's not obscene, not under the Roth test. He relied on what he called the pandering aspect of Ginsburg's operation. He wrote, "The leer of the sensualist permeated Ginsburg's advertising. Quote, the content of the circumstances of promotion, sale, and publicity might be considered as an aid in determining the question of obscenity. Ginsburg's circulars," he wrote, "stressed the sexual candor of the respective publications." And he concluded that Ginsburg was engaged in the, quote, sordid business of pandering. He looks for titillation, not for saving intellectual content. And so on that basis, the court upheld Ginsburg's conviction. Harlan dissented. He wrote that the government could ban only hardcore material from the mails. Harlan had a good point, I think, when he wrote, "However tawdry these books may be, they're not hardcore pornography, and publication is therefore protected by the First and 14th Amendments." And what's more, he said the majority was guilty of, quote, an astonishing piece of judicial improvisation. Where was the law against pandering here? Justice Stewart believed that Ginsburg was denied due process on similar grounds. He was convicted of pandering, something that Stewart pointed out was an offense unknown to federal law. Black entered a vigorous dissent, now familiar for him First Amendment grounds. He said the majority had rewritten the federal obscenity statute to convict Ginsburg on an offense, quote, Congress never thought about. And he further contended that since there had been 14 opinions in the 3 cases handed down that day, no one could know in advance what was obscene, so you couldn't stay clear of breaking the law because you had no idea what the law might be. And so publishers were in danger of breaking the law because they couldn't tell what the law was. Justice Douglas also filed a dissent. He wrote, the use of sex symbols to sell literature, today condemned by the court, engulfs another exception on First Amendment rights that is as unwarranted as the judge-made exception concerning obscenity. This new exception condemns an advertising technique as old as history. The advertisements in our best magazines are chock full of thighs, ankles, calves, bosoms, eyes, and hair to draw potential buyers' attention to lotions, tires, food, liquor, clothing, authors, and even insurance policies. The sexy advertisement neither adds to nor detracts from the quality of the merchandise being offered for sale. I do not see how it adds to or detracts one whit from the legality of the books being distributed. In the second case, Michigan was convicted of violating a New York law prohibiting the publication of sadistic and masochistic books, and he was sentenced to 3 years in prison. His defense attorney argued that much of the material was of interest only to homosexuals, and therefore, he argued, it didn't meet the Roth test of prurient appeal to the average person. Brennan, writing for the majority, upheld the conviction. He said the material was designed for, quote, a deviant sexual group, and it met the Roth test if it appealed to the prurient interest of that group. Harlan concurred on the basis of his double standard for state and federal law. Stewart dissented. He said, look, this just isn't hardcore pornography. And Black and Douglas dissented on First Amendment grounds. Black, writing for the two of them, wrote, I believe that this court is without constitutional power to censure speech or press, regardless of the subject discussed. When this court makes particularized rules on what people can see and read, it determines which policies are reasonable and right. In the final case, Memoirs versus Massachusetts, we see a case involving a novel by John Cleland, an 18th century British novelist. The formal title is Memoirs of a Woman of Pleasure. Most of you probably know it by its familiar name, Fanny Hill. The Supreme Court in this case reversed the Massachusetts Supreme Court's holding that Fanny Hill was obscene. Once again, there was no opinion of the court, but Brennan wrote the lead opinion, joined by Warren and Fortas. In this case, he argued that the three elements he talked about in Roth had, as he put it, to coalesce in order to warrant government regulation. First, as he put it, the dominant theme of the material, taken as a whole, appeals to prurient interest in sex. Second, the material is patently offensive because it affronts contemporary community standards. And third, the material is utterly without redeeming social value. And for him, the last point was the key. The Massachusetts Supreme Court had ruled that a book, quote, need not be unqualifiedly worthless before it can be deemed obscene. Brennan held that that was reversible error. He wrote, a book cannot be prescribed unless it is found to be utterly without redeeming social value. This is so even though the book is found to possess the requisite prurient appeal or patent offensiveness. Each of the three federal constitutional criteria is to be applied independently. The social value of the book can neither be weighed against nor canceled by its prurient appeal or patent offensiveness. Black and Douglas concurred in the result only. They said the First Amendment protected this speech. Stewart concurred in the result simply because he didn't consider the material to be hardcore pornography. Justice White also dissented. He didn't agree that the redeeming social importance was a separate test. And Clark, who is very interesting in this case, I think, Tom Clark, a Truman appointee, had said very little in obscenity cases. And he complained that Brennan's utterly made it virtually impossible to declare anything obscene. He wrote, I have stomached past cases for almost 10 years without much outcry. Though I'm not known to be a purist, I think he meant a Puritan. He wasn't the brightest justice. Or a shrinking violet. This book is too much even for me. It's sort of interesting to me that, that Clark was offended by a book that focused on female sexuality. But after that decision, pornographers took to citing medical material or quoting lines from Shakespeare in order to protect their product because that gave them redeeming social importance. The following year, the justices basically gave up the attempt to define obscenity. In Redrup versus New York, they didn't quite come out and say this, but they basically decided that any material 5 justices said was obscene, and any material 5 justices said was not obscene. Subsequently, the court reversed obscenity determinations against a number of publications if they did not assault individual privacy, if there was no specific and limited state concern for juveniles, and if no pandering were involved. Each justice seemed to have his own definition of pornography. For Justice Whizzer White, apparently, there couldn't be erections or intercourse, or any portrayal of anal or oral sodomy. That would make it obscene. Brennan apparently drew the line at erections. Stewart had what he called his Casablanca test. He'd been a lieutenant in the Navy during World War II, and as watch officer, he'd seen the men bring back locally produced pornography that was much rougher than anything that came before the court. And as he put it, he knew the difference between the hardest of hardcore pornography and what the court usually saw. It's hard to tell what Thurgood Marshall's standard was. He seemed more amused by the whole thing than anything else. Douglas and Black always claimed that whatever it was protected by the First Amendment. By 1970, 41 states prohibited the distribution of sexual materials to minors. And back in 1967, Congress had created a commission on obscenity and pornography. And that commission produced a report in September of 1970. It concluded that pornography had very little effect on sexual behavior or crime. The commission recommended that laws governing the sale and distribution of sexual material should be imposed only on public display. They couldn't be displayed publicly, but they should be allowed to be sold. And they also said that you could restrict, it would be a good idea to restrict sale to juveniles. Then President Richard Nixon rejected the commission's, quote, morally bankrupt conclusions and major recommendations. So for 6 years after Redrup, the court reversed obscenity convictions on a per curiam basis. In other words, the court just announced its decision if 5 or more justices voted to declare something obscene or not obscene. Within the court, the procedure came to be known as Redrupping. And the court reversed more than 24 obscenity convictions. The court, during this period, tolerated pretty much everything but the most hardcore pornography. But the court was changing. With the departure of Black in 1971, Douglas became the sole remaining First Amendment absolutist. In 1973, with 4 Nixon appointments in place, the court issued 2 decisions. The cases really dealt with whether states could ban consenting adults from walking into a theater or going into a store and buying anything they wanted. Neither case presented an issue of presenting this material to the public who wasn't interested in it, or presenting it to juveniles. But the new Chief Justice, Warren Burger, really did hate smut peddlers, and he wanted to suppress them. In Miller versus California in 1973, Burger tried his hand at dealing with the issue. Miller was convicted of a California law making it a misdemeanor for knowingly distribute obscene material. He sent 5 unsolicited brochures through the mail with sexually explicit material. Somebody who got the brochures objected. Burger wrote, once again, for a 5-4 majority. These decisions were often decided by a razor. Burger upheld the conviction and upheld the law. In his opinion, he reaffirmed the idea that obscene material lacked constitutional protection, and he also reaffirmed the first 2 parts of the standard Brennan had established in Memoirs. The average person applying contemporary standards would find the work taken as a whole appeals to prurient interest, and the work depicts or describes in a patently offensive way sexual conduct specifically defined by applicable state law. But he rejected the 3rd part of Brennan's test in Memoirs, that the material had to be utterly without redeeming social value. He offered an alternative, lacking serious literary, artistic, political, or scientific value. And the trier of fact, either the jury or the judge, would apply, quote, contemporary community standards. But those contemporary standards would be local standards. In many ways, it was a typical opinion for Chief Justice Burger. It was rambling. A lot of it was devoted to quarreling with Brennan's dissent. And Brennan did dissent, joined by Stewart and Marshall. He said the California statute was simply too broad, and Douglas now alone dissented on his absolutist First Amendment grounds. The same day as Miller, the court handed down another decision in a companion case, Paris Adult Theater versus Slayton. Slayton was district attorney. Burger, writing for the same 5-4 majority as in Miller, held that the state had the power to regulate the showing of obscene material in places of public accommodation. The case came from Georgia. The Paris Adult Theater in Atlanta was convicted of showing X-rated films. One of them was called The Magic Mirror. The other one, and this title really doesn't bear much thinking about, was It All Comes Out in the End. Don't really want to see that one. Paris Theater did not have any advertising outside. There was simply a sign that read, Atlanta's finest mature feature films. And it also had a sign on the door, adult theater. You must be 21 and able to prove it. If viewing the nude body offends you, please do not enter. So they weren't inflicting this material on anybody. But the trial judge found that pornographic films had constitutional immunity from state regulation because they're shown to consenting adults. The Georgia Supreme Court overturned that decision, and Berger agreed with the Georgia Supreme Court. Brennan entered a long dissent. Brennan becomes an interesting figure, I think, at this point. He had been the lead in trying to separate obscenity from other material and arguing that the state could, in fact, but ban obscene material because you could define it. Now he said the court had failed to reach a workable definition of obscenity. They'd failed to come to any sensible distinction between protected and unprotected speech. And therefore, he said, the court should just accept the report of the Commission on Obscenity. He wrote, "Our experience with the Roth approach has certainly taught that the outright suppression of obscenity cannot be reconciled with the fundamental principles of the First and 14th Amendment." Douglas dissented, but his dissent is interesting. Brennan had moved closer to Douglas, and Douglas bitterly pointed out that if Brennan had taken this position when they had enough votes, it would have meant something. Now, thanks a lot, it's too late. In a related case decided the same day, Kaplan versus California, Berger, writing once again for the same majority, held that states could constitutionally prohibit the sale of obscene books to anyone, including adults, including consenting adults. Murray Kaplan, the proprietor of the Peekaboo bookstore, I like that, in Los Angeles, was fined $1,000 for selling a paperback book titled Sweet 69. You don't need to guess what that's about. And he sold it, unfortunately, to an undercover cop who had come in and asked him if he had any good, sexy books, which sounds to me like entrapment, but apparently not. Douglas, Brennan, Stewart, and Marshall dissented. Berger, I think typically, was very proud of his work in the three opinions. In one of his opinions, he bragged that for the first time in 16 years, quote, "a majority of the court has agreed on concrete guidelines to isolate hardcore pornography from expression protected by the First Amendment." But Berger got it wrong. He reached too far, he overestimated his own abilities, and he certainly overestimated his own accomplishments. A few weeks after the decisions, the prosecutor of Albemarle County, Virginia, announced that he would prosecute anyone selling Playboy magazine on newsstands. He announced that the magazine violated community standards. Well, for those of you who aren't up on East Coast geography, Albemarle County houses Charlottesville, Virginia, home of the University of Virginia. And if you've ever walked down Fraternity Row in Charlottesville, let me tell you, Playboy does not offend contemporary community standards in Charlottesville. When Berger read the news story about the Virginia case, he immediately sent a memo to the Judicial Conference, to the other justices. He said, "Look, I didn't mean to ban Playboy." But that's exactly where it led. And then the court had to deal with the job of sort of putting the genie that Miller had let out of the bottle, if not back in the bottle, at least under some constraint. In Jenkins versus Georgia, the court overturned the conviction of a movie house in Albany, Georgia. The operator had been fined for showing Carnal Knowledge. Now, some of you may not remember Carnal Knowledge, the film. It was directed by Mike Nichols. It appeared on many critics' best 10 lists of that year, and Margaret won an Oscar nomination for her role in that film. When the film was shown on movie day in the court, there was none of the usual wisecracking or cackling or knee slapping. Thurgood Marshall complained, "I thought we were going to see a dirty movie. The only thing obscene about this movie is it's obscenely boring." Yet on the same day as Jenkins, the court ruled that juries could apply local rather than statewide or national standards in a case involving a conviction under federal law for using the mails to carry an obscene ad for an illustrated version, I love this, of the report of the Obscenity Commission. Somebody actually took the government report of the Obscenity Commission, put some illustrations in the stuff they were talking about, and sold it as a book. The Supreme Court upheld the conviction. Look at the mixed messages the court sent on that day. In one case, they allowed local standards to prevail, no matter how provincial. In the other case, they overturned local standards if the appellate courts thought that the local standards were too provincial. And the court added to confusion 2 years later in Young versus American Mini Theaters. The court sustained the use of zoning to prohibit adult theaters in certain areas. In this case, Justice Stevens, John Paul Stevens, who's still on the court, introduced what he called a hierarchy of values. He said some speech, political expression, for example, is fully protected under the Constitution. Some speech, like fighting words, is not protected under the Constitution. In between those two extremes, some speech is less valuable than other speech, but still entitled to some protection. And some categories, such as sexually explicit material, could be subject to more stringent government regulation. Stevens used that same test to uphold the FCC ban on George Carlin's famous Filthy Words Act on radio. The FCC issued a rule that indecency in broadcast was, quote, the exposure of children to language that describes in terms patently offensive as measured by contemporary community standards for the broadcast medium, sexual or excretory activities and organs. The standard is interesting because it did not require that the language appeal to prurient interest. It specifically rejected the idea that material could, quote, be redeemed by a claim that it has literary, artistic, or political or scientific value. It based its tighter standard for what it called the invasiveness of radio. It comes into your home whether you want it or not. Of course, you can't turn the off button, but the FCC seemed to have missed that. The FCC ruled that Carlin's routine, which was about the 7 words that you can't say on public airwaves, and which aired on WBAI, was patently offensive because children might be listening, and it was aired in an hour where children might well be listening. It rejected, under this new standard, Radio Pacifica's claim that Carlin was, quote, a significant social satirist of the American language. Justice Stevens wrote for a 5-4 majority again, but even then, he was joined, in his opinion, only by Berger and Rehnquist. Powell and Blackmun agreed with the result only. Stevens approved the FCC's interpretation that indecency could be broader than obscenity. The FCC's definition, patently offensive as measured by contemporary community standards, was acceptable even though it controlled constitutionally protected speech. It was acceptable because of the peculiarly invasive nature of radio and its, quote, unique accessibility to children. Basically, the court accepted the FCC's analogy to the regulation of a public nuisance. One has a right to maintain a pigsty, but not in an inappropriate place, such as a residential neighborhood. What's interesting about Stevens' opinion is how easily it brushed aside the Butler Rule. Remember that from 1957, that adults could not be denied material because it was inappropriate for children. Stevens said, well, look, adults can get this material elsewhere if they want to get it. Justice Powell wrote a separate concurrence in which Blackmun joined. He wrote, I do not subscribe to the theory that the justices of this court are free generally to decide on the basis of its content which speech protected by the First Amendment is most valuable and hence deserving the most protection, and which is less valuable and hence deserving less protection. Powell based his concurrence, because he agreed in the result, on the invasiveness of radio. Brennan blasted what he called the court's regrettable decision, and he pointed out, I think absolutely accurately, that it contradicted Butler versus Michigan. The 1980s saw a number of new developments in political attacks on pornography. Traditional moral and religious objections were now joined by a feminist analysis. In 1983, the city of Minneapolis, the city council in Minneapolis, passed an ordinance against pornography. It based this ordinance on the theory that pornography violated the constitutional rights, civil liberties of women. The campaign to ban pornography in Minneapolis was spearheaded by 2 feminists, Andrea Dworkin, a writer, and Catherine McKinnon, then an associate professor of law at the University of Minnesota. The mayor vetoed the bill, but the next year, the city of Indianapolis adopted an ordinance against pornography on the constitutional ground of promoting civil rights and gender equality. The argument was pornography promoted sex discrimination. And the theory was therefore that civil rights guaranteed by the Constitution gave the state a compelling interest, and therefore allowed restriction of First Amendment rights. The law defined pornography as, quote, the graphic, sexually explicit subordination of women, whether in picture or words. And it got fairly specific. Materials that present women as enjoying pain, humiliation, or rape. Materials that present women as degraded, tortured, filthy, bruised, or bleeding. You sort of get the idea they were getting a kick out of writing this stuff. Or material that presents women in postures of servility, submission, or display. And they made no exception for artistic or literary merit. In November of 1984, a U.S. District Judge, Sarah Barker, struck the law down. She noted her agreement with the city's concerns, and she reaffirmed that pornography did not have the protection of the First Amendment, but she found the goal of preventing an undefined social damage to women simply wasn't convincing. It wasn't specific enough to warrant restriction on free speech, and the Seventh Circuit Court of Appeals upheld her decision. Supreme Court declined to review it. But the winds of change were blowing politically. In May of 1985, a new Attorney General, Ed Meese, appointed a new commission on pornography. They held hearings for a full year and issued a highly controversial report in July 1986, and they concluded that there was a causal link between violent pornography and aggressive behavior toward women, including rape and physical abuse. Isn't it interesting that a presidential commission appointed by a liberal Democratic president said, you know, we looked at all the scientific evidence and there's no link. And now we have a presidential commission appointed by a conservative Republican president, and particularly a conservative attorney general, and they found that there was a link. Presidential commissions find whatever the president or the attorney general wants them to find, basically. In any case, a number of social scientists, including some who had contributed to the commission, said that they thought the report abused the findings of science, or social science, such as it is. In Pope versus Illinois, the Supreme Court decided that the court should ask whether a reasonable person would find serious value in the work in question. That strikes me as an unusually silly standard. Reasonable people, remember, attacked Beethoven's Ode to Joy as indecent. Reasonable people can disagree on these things. Florida, based on this, passed a law in the 1990s that permitted anyone offended by a bumper sticker to complain to a police officer who would then use his own judgment as to whether or not to file obscenity charges. The first arrest was for a bumper sticker that read, "Shit happens." The second arrest was for a bumper sticker that read, "Russia sucks," which is a position which many in the former Soviet Union undoubtedly would agree. Clearly, that's political speech. It's not enlightened or particularly sophisticated political speech, but it is political speech. One woman was pulled by a cop for a bumper sticker that read, "Humpty Dumpty didn't fall, he was pushed," which gives you an idea of how silly these things can get. In the 1990s, Mitch McConnell, Republican senator from Kentucky, introduced legislation that would have allowed victims of rape to sue producers of pornography if the pornography, quote, caused or inspired the crime. And a surprising number of feminists supported this right-wing Republican. It's a curious alliance, and you would think that both sides would wake up in the morning, look who they crawled into bed with, and be a little bit alarmed, but apparently not. The 1990s also brought a new issue, the internet. There's plenty of sexual material on the internet. And the question became one of children and their access to such material. And let's face it, especially in the 90s, kids often knew a whole lot more about the internet than their parents. The controlling precedent in this particular case was Sable Communication, a 1989 case known as the dial-a-porn case. In 1988, Congress voted to ban obscene or indecent phone services entirely. They didn't distinguish between indecent, they didn't define indecent. But the legislative history, if you look at the debates, clearly indicates that they had in mind the patent offensiveness that the court had approved in the Pacifica test. The Sable decision was written by Justice Byron White. He reiterated that, quote, sexual expression which is indecent but not obscene is protected by the First Amendment. The Pacifica decision, he wrote, was an emphatically narrow holding. It didn't ban indecency. It didn't regulate anything other than broadcasting. Government could, he said, regulate constitutionally protected speech, but only when it chooses the least restrictive means to promote a compelling interest. And White held that the government had a compelling interest in, quote, protecting the physical and psychological well-being of minors. And that included shielding them from, quote, the influence of literature that is not obscene by adult standards. He found that the law in question, though, was, quote, not narrowly tailored. In other words, it wasn't just intended to protect the compelling interest of preventing minors from being exposed to indecent telephone messages. And because the government never demonstrated that other methods short of this complete ban were insufficient, the court said this law was simply too broad. Congress passed the Communications Decency Act. Believe it or not, we actually spent time doing this, but the Communications Decency Act in 1996, which applied the broad indecency standard the court had upheld in Pacifica to cyberspace. And this is where it got kind of interesting. The court made it a crime to use any telecommunications device to make, create, or solicit or initiate the transmission of obscene or indecent communication knowing that the recipient is under 18 years of age. It also made it a crime to permit any telecommunications facility to be used for that purpose, and it forbade the use of, quote, an interactive computer service to, quote, send a person or persons under 18 years of age or display in a manner available to persons under 18 any communication that in context depicts or describes in terms patently offensive as measured by contemporary community standards, sexual or excretory activities or organs. In other words, you can't show dirty stuff on the internet. The patently offensive phrase was taken from the FCC's definition of indecency, and remember the court upheld that in Pacifica. The use of that standard did not require that the speech in question be lascivious or appeal to prurient interests in order to be regulated. What's more, indecent or patently offensive speech could, in fact, have serious literary, artistic, or political, or scientific value. The wild card was display in a manner available to minors. Think about it. That's all of cyberspace. And in two cases, Reno versus ACLU and American Library Association versus Reno, the court came to grips with some real problems in the Communications Decency Act. Sites that discussed safe sex were deemed obscene by the language of the Communications Decency Act. Some gay rights sites were deemed obscene under the CDA, the Communications Decency Act. And there were also problems with keyword filtering. Keyword filtering eliminated access to sites that contained the word breast, which eliminated sites about breast cancer, which really wasn't what they intended. It eliminated sites that contained the word sex, which meant that it eliminated all references to Middlesex County or Ann Sexton, or a whole variety of other things that contain the word sex. Clinton's Justice Department chose to defend the CDA by deluging justices with examples of some really raw pornography available online. The three-judge panel of the Third Circuit struck down the CDA. They said that under the Sable decision, the court did not use the narrowest, the least burdensome method for screening out minors. John Paul Stevens wrote for the majority when the case got to the Supreme Court. He affirmed the Third Circuit ruling that the CDA did not use the least burdensome method for screening minors. He rejected the Justice Department's argument that cyberspace should enjoy less First Amendment protection than magazines or movies. Therefore, strict scrutiny applied. The terms indecent and patently offensive, he ruled, were overly broad. For Stevens, I think this case was something of an apology for having written the Pacifica decision. He has never, to this day, specifically disavowed that decision. But in a speech in 1993 at the Yale Law School, he blamed the result in that decision on poor legal strategy by Pacifica's lawyers. It was a way of Stevens saying, look, I'm really not happy with what I did there. Reno was his chance to modify it. And there, more or less, you have the confused, and I think confusing, constitutional disaster area of obscenity law. In attempting to define what is obscene, the court has basically failed. It's not only failed, it's produced results that it never intended. It's produced results that shocked, dismayed, and astonished the justices who wrote the opinions. It's part of the problem is that encroaching on constitutional liberty without proof that speech is, just as Douglas said, either an act or so closely brigaded to act, so closely associated with an act as to be indistinguishable from it, it's very hard to find that in obscenity. A lot of the evidence of the so-called harm of pornography confuses covariation with cause and effect. For example, you have a rapist, and the police find pornographic material in the rapist's apartment or in his house. Does this mean that the pornography caused him to commit the crime? Or does it simply mean that rapists like pornography? Or that this rapist likes pornography? On the other hand, The courts have come to some fairly clear grounds for limiting. There's a general consensus that pornography is harmful to minors, and that the state has a compelling interest in restricting access of young people. The courts have upheld that. There's also the question of the so-called captive audience. Those who find obscenity objectionable shouldn't be subjected to it against their will. Magazines can be displayed, you put under the counter, have covers put on them. They don't have to be shoved in the face of people who will be offended by them. But beyond that, let's think about where the court has gotten us. And maybe we should return to the First Amendment itself, the preferred freedoms doctrine. This is a judicial idea, judicial doctrine from the late 30s and early 40s, that the Bill of Rights was so essential to our way of government that there would have been no Constitution without the Bill of Rights, and that therefore judges should take a more active review when government, at any level, restricts some of those rights. In fact, the justices argued that the court should reverse the presumption of legislative correctness. Now, what that means is when judges review a statute, they're supposed to assume that the legislature's right is the burden on someone complaining about it to prove that it violates the Constitution. They said when the state or federal government or local government restricts First Amendment rights or any of the first 10 Amendment rights, then the court should reverse that presumption. It should be up to the state to demonstrate clearly that it has a compelling and justifiable interest. Because I think I think that's a good place to think about, a good idea to think about, because think about the consequences when we start down this slippery slope. Under Miller, obscenity remains illegal, but even under Miller's relaxed requirement for obscenity, that material, it's going to be hard to find material that juries will say is obscene in a lot of cases. I don't think there are very many juries today in America that would be likely to rule that the Playboy website was obscene. And yet most people would deem it inappropriate for minors. So the problem comes down to this. Who's going to make these determinations? Who are you willing to allow to make these determinations for you? The problem with obscenity is that Justice Stewart was wrong. We don't know it when we see it. We know what's obscene to us. I know what's obscene to me. I know what I don't want to see. But one person's obscenity is another person's art, and yet another person's harmless, if useless, junk. We live in a pluralistic, complex society. Under the First Amendment, there has to be room for individual judgment. Our Constitution is based on the idea that each person must choose for him or herself. And as Justice Douglas noted, we trust the American people to make judgments about politics and religion and economics. It seems rather ridiculous that we single out obscenity as one area where we don't allow mature adults to make such distinctions. And I think once we've gotten into the area where somebody else starts making those decisions for us, somebody else can decide what we read or what we see, particularly in the privacy of our own homes. I think we've lost a basic component of our democracy. And that's something not to be taken seriously, particularly on Constitution Day, which is actually tomorrow, when we're supposed to be thinking a bit about the Constitution. Thanks very much. And I'll be glad to take some questions if anybody has one or more. No one has them. We can all go home. Oh, question. Okay.
Just a minute, I have a microphone.
Okay. Wait, sorry. We need to get a microphone for you. Don't let it intimidate you.
Awesome. Thank you. Okay, so
Mute switch somewhere.
hello.
I think you just push a button.
Okay. So speaking of obscenity, okay. Speaking of obscenity, the Confederate flag issue on campus, how do you think that falls within the definition?
Well, it doesn't. It doesn't really
Okay.
deal with obscenity. That can be. That's a complicated issue. It's a very good question, but it's a complicated issue for a couple of reasons. One is one could regard that as political speech, which would clearly be protected. One could also regard it as offensive. But in this case, it's a question. I think it comes down to a question of rules about public display. The university has rules against publicly hanging these things outside of windows and so on, which are acceptable. Now, almost 20 years ago, the university attempted to restrict what students could hang in their own rooms. That's a violation of First Amendment rights. Rented space is a legally recognized zone of privacy. The university's got no business telling you what you can hang in your dorm room. but outside display. This is, again, goes into it's in the area of public display. But this isn't obscenity. There's nothing obscene about it. You may think, you know, that the political sentiments behind it are obscene, but again, it's political speech, and as such, you can argue it's political speech, and it's protected. We shouldn't be telling people what they can do, and I know people say it's offensive to some people. Lots of things are offensive. I find a lot of political speech offensive. It shouldn't be censored. But whether it should or shouldn't be, it's not. Obscenity law is a separate area. And this is another area of First Amendment law, which is very complicated. And we've gone around and around with these things. There were the hate speech codes that I mentioned on college campuses in the early 1990s. There were attempts to regulate on this campus in the early 90s, what was the term? Culturally approved representations of rape in the curriculum and texts. Well, if we had done that, we would have eliminated a great deal of Greek tragedy. We would have eliminated chunks of Shakespeare. I teach Eldridge Cleaver's Soul on Ice. I would have eliminated that. Fortunately, the Faculty Senate blocked that. But it's not quite the same thing as obscenity, even though we may use the term that this political idea is obscene. It's not legally obscene, I guess, is the answer to your question. Does that help a bit? Thank you. Anybody else?
So then other than sex, what
That's
categorized as obscene?
That's a very good question. And again, the court really hasn't come up with that. And again, remember what Brennan said, and the justices have kind of agreed, not all sex is obscene, which is good news. It's a representation of sex that appeals to the prurient interest, that violates contemporary community standards.
Other than sex?
Not much other than sex. You can talk about certain things. You can debate whether rape is sex or not. You can.
Portrayals of things other than sex.
Pardon?
Portrayals or anything written about something other than sex.
Is probably not going to come under obscenity law. There are other restrictions, but it's not likely to come under obscenity law.
And if you're familiar with this film is not rated by
I'm not really.
Okay.
Well, you can tell me about it. I mean,
It's about the Hollywood rating system last year.
I think I heard something about that. Yeah.
Yeah. I just wondered what your take
Well,
might be on it.
Again, the Hollywood rating system is not government. People can do lots of things government can't do. This is supposed a voluntary agreement, voluntary with a gun held to their head, but it's
used based on the government's definition of obscene. The rating then says this is therefore obscene. The government says.
Yeah, no, don't say it's obscene, because obscene would not be protected by the Constitution. This is all material that, by definition, is not obscene. This is material that is restricted by age groups. In other words, you PG-13 or R or X or NC-17.
Well, then,
none of this material is
why
banned.
are not the gutted children and regular people and old people from various war grounds around the world, those depictions are not obscene, or they are obscene? It seems that because they're banned from our vision, our view, the public's not allowed to see horrendous results.
Well, what do you mean? What do you mean banned?
From what I understand, recently they can't show what would be horrendous graphic.
Who can't show what would be?
Media, television, and I guess magazines. I would imagine. I don't.
Now it's. First of all, there's a question whether this is government regulation, and as far as I'm aware, this isn't official government regulation. Second, there's also the issue of broadcast, and broadcast versus cable, but even cable, you get back to the question of invasiveness. Once you start banning stuff, whether it's horrible mutilations or something, and some people, again, some of that does come under obscenity, because some of that is.
It does? It comes under obscenity?
Because you look at some of these slasher films, there's sort of that bizarre, to me, conjunction of sort of sex and violence. These, you see in slasher films and things like that. I don't see in slasher films, but some people see in slasher films. But again, you're confusing, I think, industry regulation and government action. And I'm not sure that.
I'm just thinking industry regulation is supported by government action or dictate or ruling.
Well, there are differences. As I said,
I understand they're different. I'm just saying that I think they're cited. Whatever the government might say is obscene or not obscene is then therefore cited by anyone else who says it's obscene. And I'm also just somewhat taken aback that the only thing that's obscene is human sexuality. Nothing else is obscene.
well, that's not quite true.
I know
but
it's not
basically,
quite. I know
yeah.
I may
Yeah.
be stretching the main or central point too broadly for comfort. However, still, you got the slasher in there, but the slasher was raping at the same time. It wasn't just slasher for slashing. If killing for killing without sex is not obscene, but killing with sex is obscene because sex is in there, and sex is it seems like the worst thing. You said we don't regulate for all these other things that we do in our society or departments of government that we have, but we do regulate this idea of what we do with our bodies or don't do with our bodies.
Yes, we do. I mean, which is, I think, the basic point I was making, and it can be considered. Well, I think that a lot of the regulations are ridiculous, and I think if you look back over history, looking back at regulations of obscenity have been do in many cases look ridiculous. But again, I think you need to be careful because government action is very different from an industry standard. It's, and this material is not prohibited. It's not shown on the air. There's a difference. And this goes back to the difference between Sable and Pacifica.
There's a difference. I do think, however, that it has an influence or has some kind of effect on what people consider is obscene and not obscene. If someone comes in here and Tommy guns everyone to death, that's not obscene. But if someone comes in here and has sex, consensual, and it's filmed, then that is obscene. Is it?
Not necessarily, but
Not necessarily. Okay. All right.
yeah. Oh, yeah. I'm sorry.
I've been interested in seeing people arrested from time to time for certain things they've downloaded or put on their computers. Has the court ruled on that specifically, or is that under the broad Telecommunications Act?
Yeah, it depends. It probably comes under the CDA. You'd have to sort of talk about specific things. But people, again, to me, the business about people possessing pornography and internet pornography has been used. And child pornography gets into a really tricky area. But even in that area, it seems to me that making child pornography is clearly a crime. It's punishable. Possessing it, we tend to, now it is, but that gets into a very, very touchy area. Because again, presumably the damage is done. It's actually not unrelated to the point about what violence can be shown. But if you look back, I mean, if you look at a movie, if you get a bunch of people killed, it's still PG-13. If you have somebody take off clothes, then it's more likely to get an R. I mean, it is. We do have some sort of strange standards. Yeah. Oh, sorry.
Missoula and other municipalities regulate where adult establishments can be. And I think part of the standard is how close one of these things is to a school. So my question is if a school board acquires some land and decides to build a school, are the rights of that business person who had the adult establishment, lived within the local statutes, is he required to then close?
It's a very good question, and maybe so. It's you could argue that both ways. It could come under public takings, basically, or it could be a denial of property without due process. And a lot of that would have to do, I would imagine, with state law. Jeff Rentz just left a little while ago. He's much more familiar with Montana law than I am, and could tell you a good bit better about what would be the case here. But that's exactly the case in the Paris Adult Theater decision. The question was, did the state have the state of Georgia in that case, have the authority to regulate the place, the zoning of these institutions, adult theaters? New York's dealt with the same. New York City's dealt with the same thing, Times Square and so on. And the courts have consistently held, yes, you do have the ability to regulate where they are. And then you've come up with a great example of just how complicated what seems like a simple regulation can get in actual practice during the course of a legislative life. Was there a hand in? Yeah.
Yes, you may know that two or perhaps more professors in the English department teach semester-long courses on Ulysses. I'm very interested in the Woolsey decision in 1933, United States versus one book called Ulysses, which you mentioned. I dig around in some of the documentation of that case, including Woolsey's letters at Yale and Bennett Cerf's papers and letters.
Bennett Cerf was a publisher.
Yeah, at Random House. I find that there was something somewhat incorrect or improper or perhaps eccentric about Woolsey's decision. And I wonder if you would have an opinion about this. Woolsey said that near his conclusion that after he had made his decision, he asked two of his friends, which he called literary assessors, to read the book and then to offer their opinions. They did not know each other and so on. But they were not experts, and Woolsey did not appoint what I think is called in law a special master, an authority on the subject of obscenity. They met the qualification in Woolsey's mind that they were his friends. They were both men. He admired their opinions on literature and life, and he thought they represented, his expression was l'homme moyen sensuel, that the typical sensual person, typical sensual male. He said both friends concurred with his opinion, but I wonder what would have been the consequence if either or both of them had found it obscene. But what was Woolsey's right in his opinion? He did not name those persons. They offered no qualifications to their expertise, and yet this decision, which seems to me odd and eccentric, was not a topic in the appeal papers. And as you said, the appeal was upheld by the appeals court, so it did not go to the Supreme Court. Do you have a comment?
Right. Well, a couple of things. I mean, this is part of the difficulty of obscenity. I mean, who's an expert? Who's a literary expert? What's a literary expert? What offends somebody doesn't necessarily offend somebody else. I think you need to be a little careful. There's a difference between a special master and a witness. A special master is appointed to preside over and make certain decisions in which an expert is required. Maybe in a technical case, a patent case, they might appoint a special master. And in a number of times in civil rights cases, they'll appoint a special master. A qualified expert is somebody the court who is subject to voir dire by the other side in the court, and the court certifies somebody as an expert. And that's an expert witness. And what Augustus Hand decided, who was the appellate judge who wrote for the appellate court in the Ulysses case, was that because the appellate judge doesn't retry the case. The appellate judge is simply there to decide matters of procedure and law. And he held that, so it wasn't up to him to decide whether or not these guys were necessarily experts, because it wasn't presented to him. His decision was simply that the opinions of experts was a legitimate way of determining whether or not a book was obscene, if the book had literary merit. Now, if Woolsey, in private, sort of did not or consulted people for their opinion who weren't experts, and it persuaded him one way or another, that's improper. But I don't think it much affects the appellate decision in Ulysses. I don't know if that answered your question, but that's about the best I can do with that without seeing some of the material. Is that it? Oh, okay.
I have a question relating to all that there. What we heard tonight was basically, what we heard tonight was a historical analysis of the Supreme Court's regulation of obscenity. And I wonder if, did they go through the same contortions with regulating graphically violent material? Were there ever any, do you get my
yeah, I mean, there have been, but I think that most of the decisions relating to that deal with the question of public display. And again, I think one of the points you need to make, there's a difference between saying you can't put it on the air, or an industry code that says don't put this on the air, and saying you can't produce this material, you can't view this material. That's an important distinction in obscenity law. And it applies in this sort of area too. You shouldn't have this sort of thing in places where people will be offended by it. Now, I know you see on the cover of Time magazine, images from war-torn wherever that are very disturbing, and then maybe a lot of people would say aren't really appropriate for children. Our society does seem to have a greater tolerance for certain kinds of violence or violence than it does for sex. Lenny Bruce, the comedian who often ran afoul of obscenity law, used to do a routine where he'd say that he couldn't understand what this whole business with obscenity was, because, what the big concern about pornography, because, as he said, the only instrument of violence you ever see is a pillow, and usually it goes under somebody's behind. Nobody was being smothered by it. And he said he'd rather that his children grew up with that use of the pillow than with the use of the pillow to smother somebody. And I guess, if you ask me, I'd probably be more on his side than the other, but it goes back partly to contemporary community standards. Again, if you want those standards changed, vote for different people.
Well, so just to reiterate a more simpler question was, did the court from, say, the 1850s on, did they struggle with that issue at all?
Not really. You don't see that early. That really doesn't become as much of an issue until films of the 60s, 70s, 80s. And also with the development of much more portable cameras and visual images. And so you get questions of war. NBC debated at great length. You all may have seen, or if not the film, at least the still image, where the Viet Cong prisoner during the Tet Offense is brought to the Saigon chief of police. He just puts a gun to the fellow's head and pulls the trigger. They cut the last 17 seconds when they did show that on NBC, because it just showed the corpse pumping blood into the street. But NBC debated long and hard whether they would put that on the nightly news, and John Chancellor's report, and they did. In the end, they did trim it. But that was not a question of government regulation, which is, the Constitution doesn't protect you from me necessarily, the First Amendment anyway. It protects you from government action. It says the government can't restrict your free speech, and so on. There often, sometimes there are state laws, but you need to be careful. Again, industry regulations are agreements, and people can enter into all sorts of agreements. Now, the issue was raised about government coercion, and there is. I mean, the government leans on industries a lot of times to regulate things. And since the New Deal, government the courts have given government a great deal more space to regulate commercial and other activities than free speech, and television, other things come under that. And so when it goes back to the point I think I started with. Once you give government power to start regulating these things, it's very hard to determine what the boundaries of that regulation should be. And we've gotten into trouble repeatedly, I think, with that. I mean, why are we spending it's interesting, we're spending time talking about it today. The Supreme Court spends a lot of time talking about it. Surely there must be other things that are greater threats to the Republic. Anybody else? Because we're getting late. Okay, thanks very much. I appreciate it.